Welcome to another episode of the SNA Speakeasy. We have a very exciting guest today. That's Lawrence Repeta, who I think a lot of people remember him as a longtime resident of Japan and one of our best go-to people for issues of legal matters in Japan. First of all, Lawrence, why don't you tell our audience what you're up to these days and a little bit about your background and your interests?
Well, I first came to Japan a very long time ago. And I started work in Japan after I graduated from law school, and that was in 1979. I moved to Tokyo and I took my first job working with a Tokyo law firm. So since that time, and even before that time, I've really been interested in Japanese law. And over the years, I took a special interest in the Constitution. And so I've done, quite a bit of study of the Constitution, a little bit of writing. And I find it's really it's a fascinating topic.
Today, of course, we're looking at a very specific issue, which is COVID-19. So what has been the debate about the Constitution so far in the COVID-19 crisis?
Well, I particularly became interested in the topic when I was reading a Western newspaper that carried the statement that the reason Japan does not have a mandatory lockdown is because in order to do so, Japan would have to revise the Constitution. I read that and I thought, that can't be right. And so I did a little research and I actually exchanged emails with a number of Japanese constitutional scholars. And they all agreed with me that certainly there's no need to revise the Constitution in order to address the coronavirus, in order to create a mandatory lockdown if that's what the government decided. Clearly, the Diet under the Constitution as it is has the full authority to adopt legislation to do that.
Well, it's interesting you should say that because, as you noted, almost every press account has made this claim that the lockdown could not possibly have any mandatory or requirements on the people because the Constitution made that impossible. And it was very clear to me that since this came out in just about every news article simultaneously in Japan, the only reason that would ever happen is because that's what the government has briefed to the press. They have said this. And in fact, Abe has also made public comments along the same lines. So why is it that the government is claiming that the Constitution doesn't allow them to make requirements of the people in a time of emergency?
Of course, the first thing is the message to professional journalists is if you get a question like that, contact an expert, a constitutional scholar. You can call any large Japanese university, talk to a constitutional scholar and get the word from an expert rather than the spin you get from some political person. So why would someone speaking on behalf of the Abe administration suggest that it's necessary to revise the Constitution? Well, it fits entirely with their program. That the LDP, as Mr. Abe recently repeated, has been calling for a comprehensive revision to the Constitution ever since the party was founded in 1955. I'm referring to a talk that Mr. Abe gave on May 3rd, which is Constitution Day in Japan. And in a typical year, there are lots of public marches and speeches, and the newspapers are filled with articles discussing the Constitution. This year, of course, there were not public demonstrations and parades. But Mr. Abe gave his Constitution Day talk. It's available on YouTube. It was delivered to a group called the Kempo Forum, the Constitution Forum. Um, he spoke for about 9 minutes. I watched the YouTube version. During the course of his comments, he mentioned that, of course, we, the LDP, stand for a fundamental change to the Constitution. 2 years ago, the LDP kind of whittled down its much broader comprehensive program and said, well, we need to focus on 4 particular revisions to the Constitution. During his May 3rd comments this year, Mr. Abe mentioned 2 in particular. One is the demand that an entirely new provision be created, a provision that would give the government emergency powers during some kind of special circumstances. The second is related to Article 9, the pacifism provision.
And talking specifically, have you studied or are you aware of what are the proposals of the Liberal Democratic Party in terms of their emergency powers? How should we say proposals? What are they?
Yes. Back in 2012, the LDP published a comprehensive program for revision of the Constitution. It would go from the start all the way through the end. They actually published a 64-page pamphlet which explained all of the changes they proposed. And with regard to emergency powers, the LDP would create an entirely new provision. That provision would say that the cabinet would have authority to declare a national emergency. And during that period, the cabinet would be able to adopt cabinet resolutions, which would have the same effect as law. So it would empower the cabinet to bypass the Diet. When we think about the Diet or any national legislature, I mean, that really is the house of the people. It's the branch of government in which we have the representatives that we've elected to represent us and to deliberate and create the law. The hearings are generally open to the public. Many of them are televised. The votes are recorded. It's a public procedure that everyone can be aware of and, in fact, can influence potentially by contacting our representatives. On the other hand, cabinet meetings take place in secret. There's no requirement that they be held open. With regard to Diet proceedings, of course, it's not only the ruling parties that speak. Also, the opposition parties have an opportunity to ask questions and to speak out. If we're inside the cabinet room, there is no participation by any opposition party members. The proceedings can take place completely in secret.
Well, let's see how far that goes. So let's say, for example, this constitutional amendment was passed and there was an emergency and the cabinet took the authority that you're talking about. Under such circumstances, would there be any checks and balances on the cabinet's power at that time? And or would there be requirements on the cabinet to document very carefully what decisions it made and therefore face some sort of serious review afterwards to determine whether or not they abused their power?
So 2 questions. One is about checks and balances, and the other is about a public record, I think. And of course, when we talk about this, there is no such provision. We have not experienced life under such a provision. So we're simply, looking into the future and trying to hypothesize what might occur. With regard to checks and balances, it doesn't appear that there would be any checks and balances. I mean, until an emergency period was finished. The cabinet could extend the emergency periods, so there's no guarantee that they would come to an end, but presumably they would, and then the Diet would resume operations. And checks and balances, we ask about the courts. That poses another problem. I mean, first, the Japanese Supreme Court has been extremely reluctant to rule that any government actions violate the Constitution. And second, and in this case, more problematic, the Japanese Supreme Court has adopted an act of state doctrine. In the United States, we call it the political question doctrine. The Supreme Court has said, with regard to matters that are especially within the province of the elected branches of the government, we will not review them in court. We will not exercise the power of judicial review. So in this case, if there were an actual emergency and the cabinet declared an emergency, my fear would be that with regard to any check and balance, the courts would simply not review that action.
And the issue of recording and documentation and sort of a ex post facto review of their actions. Is there any sense that this would be done in a responsible manner?
Well, I believe the year was 2012, but a few years ago, Japan adopted a Public Records Act. And the Public Records Act requires that government agencies document decisions of importance. However, we have seen that the government has failed to document important decisions. I mean, one example is in 2015, the Diet passed some national security bills. And in the run-up to the Diet action, within the administrative branch, the cabinet consulted what's called the Cabinet Legislation Bureau, which is a highly specialized office that reviews potential legislation. Well, the Cabinet Legislation Bureau created no document that records whatever discussion or review they might have had of that proposed legislation. And there have been other cases where the administrative branch has not followed the law and has not created the records that they should. So we can't have confidence that the cabinet would create a proper record that could be subsequently reviewed by other branches of the government or by the people.
Okay, well, let's get out of this hypothetical land of an emergency amendment that hasn't been passed and probably will never be passed, or at least we don't think so at this point, and go back to the current Constitution and what it allows. So, the basic contention that the government made, and which you have challenged, which is that this Constitution cannot give the government authority to mandate the protections for the people in a time of emergency. So can you speak a little bit about the resources that are available under this Constitution for the government to act in an emergency?
Well, I can talk a little bit about the law. And under the Constitution, the Diet is granted very broad authority to adopt legislation that's in the public interest. And this is subject to checks and balances. In particular, the Diet action is subject to review by the courts. And in fact, the Supreme Court of Japan on, I believe it's 10 occasions since 1947, in fact, has ruled legislation in violation of the Constitution and therefore invalid. So it's rare that the court exercises that power, but it's undeniable that the Constitution provides that power to the courts. So on one hand, the Constitution grants the Diet broad legislative authority. On the other hand, it grants the courts the power to review Diet action to ensure that it doesn't go beyond the constitutional limits. So this is the state of play and the system that we have established by the Constitution. There is no doubt that the Diet in March, when I believe it was March 14th, when it adopted the revision to the new influenza law, making sure that it applies to the new coronavirus. At that time, the Diet could have created a mandatory power. It did so, if you think, in other cases. For example, think back to the triple disaster back in 2011. And you'll perhaps remember that legislation at that time empowered the government to order the evacuation of the zone that's 20 kilometers around the Fukushima, the TEPCO power plants with the nuclear meltdown. So within that zone, 20 kilometers around that zone, around the plants, the residents were ordered to evacuate. And this was not a voluntary matter. It was a mandatory matter that was enforced by potential fines for violators.
And so, if it could be done in the case of the Fukushima Daiichi nuclear power plant issue, why can it not be done in the case of the COVID-19 crisis?
Well, it can be done. So as a matter of law, there's no question that the Diet could have adopted such a law. And as you know, the majority parties, the LDP with its partners, hold more than a 2/3 majority in each house of the Diet. So they could have adopted such a law.
I think they might have fallen short in the House of Councilors now, however. I think they don't quite have a 2/3 at the moment, but go ahead.
So certainly they have the majorities they need. They could have adopted a different law. They did not. And you ask, well, why not? And the answer is really very clear. It is that the Abe administration feared criticism. There's a great deal of fear in Japan regarding excessive government authority. And of course, it's rooted in the wartime experience. So whenever the term emergency powers is mentioned, I think a lot of people are very concerned that it might grant the government too much power, might lead to abuse of that power. And so if the government had passed a law with mandatory powers, there's no doubt there would have been an outcry among the bar associations, among academics, in the news media, and so forth. So the law that was adopted does not include the mandatory powers. And I might mention also, the news reported that before the bill was submitted to the Diet, Mr. Abe was very careful to sit down with the heads of each of the opposition parties to make sure he could get them on board.
So just to really underline and cross the T's and dot the I's, there's no constitutional bar on these sort of mandatory measures to protect the public. It's simply a matter of the legislation that the Diet has passed under the Constitution.
That's right. And as I mentioned earlier, when I first bumped up against this claim in the news media, before I wrote a brief article about it, but before I did that, I contacted several Japanese constitutional scholars at major universities, and I said, well, in my opinion, the Diet has the power. And they all said, well, you're right, of course the Diet has the power. So there's no question about it.
And which article of the Constitution, for those who want to read it, would be the one that most gives them the power to have this sort of mandatory legislation?
Well, it is the grant of legislative authority. I believe it's Article 51, right? So, when you think about a constitution, you ask, well, what is a constitution? Well, in a constitutional democracy where we have popular sovereignty, the people are sovereign, and through the Constitution, they grant authority to a government. They create the government. It's the Constitution that creates the government and grants it authority. It also imposes limitations on that authority. So in this case, the Diet's power, I believe it's Article 51, is the broad grant of legislative authority. And you ask, well, is that authority unlimited? No, of course it's not unlimited. There are cases where the Diet might go too far. where it might invade individual rights, the right to free speech or right to freedom of religion and so forth. In this case, I think the primary limitation is Article 13 of the Constitution, which says that all law is subject to the public welfare. So the highest value of law is really to serve the public welfare. In this case, the health and safety of the people.
Okay, and is there any final point that I haven't asked you that I should ask you before we move on to the question and answer section with our patrons?
Well, I just might mention, I'm sitting here in Seattle, Washington, in the United States, and many of the provisions, as a matter of law, the constitutional provisions are very similar. Here in the state of Washington, like other American states, we have a mandatory lockdown. Under Washington state law, theoretically, by violating the lockdown, you could be punished by up to 364 days in jail. So we have mandatory lockdowns. They've been challenged, right? When we talk about law, we can also talk about culture. In the United States, we have a culture that really promotes a great deal of confrontation. So we've had several lawsuits filed that challenge the government power of mandatory lockdowns. All of them have confirmed that the state legislatures have authority to pass law that creates mandatory lockdowns.
Okay. Well, thank you very much. At this point, we'll move to the Q&A section with our patrons. As you know, we have